Welcome to Part 2, Georgia Minimum Technical Standards for Property Surveys. Part 2 deals with maps and plats, the requirements to those. I'm Mark Chastain. I'm your instructor for this segment. So we're going to start with the foundation of the whole maps and plats requirement routine, which is what we've commonly known as the Plat Act. When the Plat Act was revised in 2017, though, condominium plats were brought in, so it's known as the Plat and Condominium Recording Act of 2017, not just the good old Plat Act as we used to hear it. So the title of Official Code of Georgia 15667 is Recordation of Plats and Condominium Plans, specifications. So this starts out with some simple definitions. We'll deal strictly with plats, not condominium plans. And again, the highlighted areas are highlighted by me. They're not highlighted in the law or any board rules or other official publications, but I have highlighted what I felt like needed to be emphasized. So a plat means a drawing prepared by a land surveyor that describes and depicts real property boundaries. So let's talk about that just a minute. If a drawing is prepared by a land surveyor, and it doesn't come out and say it, but basically that is sealed and signed by a land surveyor, and it describes and depicts real property boundaries. Now, what does that mean? Okay, you're not going to have a description of boundaries without having them depicted. But if it shows and describes boundaries, then you're getting into plat territory. So, there are some others, architects, engineers, geologists, that throw calls, being bearings and distances on drawings that they prepare that show property lines. That is land surveying. That is unlicensed practice by anyone other than a professional land surveyor. So the depiction would be the line work itself, maybe even the circles showing the monuments, but more importantly, the description of the monuments, adjoining owners. The bearings and distances are probably what makes that a description of the property boundary, or what describes property boundaries more than any of those other elements. That would be, the bearings and distances along the boundary line. So such a plat includes, but is not limited to, a map, condominium plat, subdivision plat, as-built survey, easement survey, or retracement survey. And again, including but not limited to. So you'll see this phrase again later, but describes and depicts real property boundaries. That's important. That will come back to us. So Part B of this code section just says that all these plats that are recorded must be filed electronically. So we want to also make another distinction at this point. Georgia is not a mandatory recordation state. Some states require that every plat that's issued be recorded or submitted to the county surveyor's office. In Georgia, that's not so. You can prepare a plat for somebody and they can throw it in the trash can, they can put it in a safety deposit box, they can forget about it, they can record it, they can wrap Christmas presents with it. There is no requirement to record it. However, if it's a plat and it depicts and describes real property boundaries and it has a seal and a signature, then it must be recordable. Now, there was a little gray area before probably the 2011 change to the Plat Act, to where some people said, well, if I didn't intend on it to be recorded, then this doesn't apply to me. And even though that's really flimsy and it doesn't hold water, that language was clarified in 2011 to include this language: describes and depicts real property boundaries. So every plat that depicts and describes real property boundaries that has a surveyor signature and seal must meet all the requirements of law and state regulations and be recordable. I might paraphrase it another way. Georgia does not have standards for a kind of survey, partial survey, almost survey, loan survey, windshield survey, plagiarized survey. It's just a survey. So paragraph C of the code section says that, for them to be recorded, they must meet the following requirements. Now, this box is something that came in just a few years ago. It wasn't there always, but the clerks, I believe this came in the misguided, ill-fated 2016 Plat Act, or revision to the Plat Act that had a lot of problems that had to be rectified quick in 2017. But this came in the 2016 Plat Act legislation and was carried over and kept. The clerk of courts wanted that. And the clerk of courts are politically represented and managed by the Georgia Superior Court Clerks Cooperative Authority. We refer to that acronym as GSCCCCA. I hope I got 3 C's in there. They regulate procedures for recording everything: juvenile court records, plats, wills, deeds, minutes, depositions, court cases, complaints, responses, all those sort of things. So they said that besides being filed electronically, so that you can't just walk into the courthouse anymore and present them with a big old plat and ask them to glue it into a book and assign it a book and page and send it off to be scanned, now we do the scanning for them and present it, and it gets recorded electronically. The 3-inch square box in the upper left-hand corner shall be reserved to the clerk to append filing information. So when you record a plat in Georgia and you e-file it, you submit it through the e-file platform through a trusted credentialed filer, then they review it supposedly, and of course that the level of review and scrutiny varies from county to county, and that 3x3 box gets the recording stamp in it. So from now on, personally, I like it. It's a good system. You can always look and see, is this plat been recorded? If the square box is blank, it might have been recorded, but you're not looking at a recorded version. If it's got a recording stamp in it, then you know it was recorded and you can proceed accordingly. So again, if it's a plat, this is a requirement. Doesn't matter if you are planning to record it, or if you know they're going to record it, or if you are 99% convinced that they're not going to record it, it's still not an option. You still have to provide the 3-inch square box in the upper left-hand corner. So I want to mention that there are a lot of folks that I'm still in contact with as an emeritus board member of the state board, and even when I was a member for 18 years of the state board. After this became a requirement, you got a really quick glimpse as to who was up to date on their regulations and knew what was going on and was required, and who was just winging it by that square box. And even to this day, especially out of state surveyors, especially the cursed national firms that have all different levels of privacy and separation and conflicts of interest, a lot of those plats don't have the 3-inch square box in the upper left-hand corner. The clerk of court has the right to reject your plat if it doesn't have it. I know of at least one county to where they chose not to fight with the one local surveyor in that county who does not put the box in there, and they record it anyway. That is at the clerk's prerogative. So, number 2, required data for plats. Each plat shall comply with the minimum standards and specifications adopted in the rules and regulations of the State Board of Registration for Professional Engineers and Land Surveyors. So, by law, all board rules are brought in and given legal weight right here. So, if you say, well, the Plat Act's only 2 or 3 pages, it doesn't include any of this information, all these details in the state board rules, so I'm not going to provide them. Sorry, they're still just as required as if they were written right into the state law. That's my opinion and my experience, because the law says that you shall comply with the state board rules. So that's part of what we're doing here. So these are basically simple, run-of-the-mill things that you would expect to see anyway. The county that the property lies, if it's in a municipality. Notice this, part C, the name of the property owner or owners of the subject property as stated on the most current or applicable title instrument. So we're required to review that vesting document of the property we're surveying. Let's say that John Doe owns it and he's selling it to Bill Smith, and our survey says survey for Bill Smith. We still need to list on that plat that John Doe is the owner. And you may say that's crazy, I don't do that, or I didn't know we had to do that, or didn't know that's why we had to do that. But the owner's name is supposed to be on the plat, and the clerk of court is supposed to index it by the owner's name if different than the name on the plat. So if John Doe is selling to Bill Smith, we put out the plat, we record it on December 31st. January the 20th, they have the closing and Bill Smith buys it. Well, when the plat's recorded on December 31st, John Doe was the owner. There will be a reference to that in the clerk's indexes for John Doe to that plat. So this adding extra layers of cross-referencing and integration of all the data. Part D, the type of plat. You can't just say survey for. Is it a boundary survey? Well, that's still a little bit ambiguous. Is it a division survey or is it a retracement survey? Basically, every survey that is issued is one of those two categories. It might also be a final plat, which is still a form of a division survey. It might be a minor subdivision plat. It might be an exemption plat. But if it depicts and describes real property boundary, you've got to tell us what kind of plat it is. If it's in a subdivision, you need that info. If it's part of a condominium complex, you need that info, along with units, pods, blocks, etc. And if it's a new subdivision or condominium, the name or names of the developer. So that's pretty straightforward enough. Also, all applicable land lots, land districts, sections, reserves, or militia districts wherein the platted property lies. So that all needs to be on there. The date of the initial preparation and issuance, and any revision dates, including what those revision dates were about. Okay, obviously we need to put the surveyor's information on there. That's not a surprise. One thing that gets overlooked a little bit is the certificate of authorization number. If you look here at paragraph K, the certificate of authorization number of the entity that performed the survey, or if it is an individual surveyor operating in his or her individual capacity with no reference to any LLC, corporation, partnership, affiliation, or otherwise, just strictly Thomas Jefferson PLS number 1, then there is no requirement for a certificate of authorization. L, the registration number of the surveyor, or that he or she is not required by law because they are a pre-1978 elected county surveyor. We don't have many of those left anymore. M, the seal of the land surveyor who prepared the plat and is signing the surveyor certification, which shall be placed within or next to the surveyor certification. So that's where the seal needs to go. And if it has multiple pages, you need to indicate that. And the scale, both stated and shown graphically, like with a bar scale. That's no-brainer, common plat requirement in every state. Going down to part 3. Now, here we get into some Georgia-specific nuances, circa 2017 revision. There are 4 Georgia surveyor certifications that the surveyor must choose from to be placed on all plats. One, but not more than one plat or certification has to apply on the plat. So this is because some local governments prefer to rubber stamp and sign plats and approvals. Some want it done electronically. At the time the law was written, these submittal portals where you can submit and they can put the approval signatures and boxes on the plat electronically and send you a PDF back. That was either really new or unheard of at the time. That's now common in a lot of the metropolitan counties. So the law was written to address 4 particular scenarios that you could easily fall into in Georgia as best we could tell, because I had a big hand in working on that 2017 legislation. So it has to be in a box. It can't just be text thrown out in the plat. The clerks wanted it drawn in a box so they could know where to look. So they look at the certification, they look at the stamp, they look at the signature, and they know it's either okay to record or not. That is at least the design. The function varies from county to county. So, certification 1, or little I in the legislative world, is for a plat that has been prepared by a land surveyor and has been approved by all the applicable local jurisdictions, as is evidenced by the certificate, signature, stamps, and statements hereon. In other words, there's a signature placed on a piece of paper or a PDF somewhere. The approvals are placed there after the surveyor issues the plat. Furthermore, the undersigned land surveyor certifies that this plat complies with the minimum technical standards for property surveys in Georgia as set forth in the rules and regulations of the Georgia Board of Registration. So, not only does the law say that we have to comply with the rules, the certification requires that we state that on every plat that we issue. That becomes very important, and we'll come back to some elaboration on why that is. But again, certification 1, little I, is for a plat that's issued that needs approval. It needs approval by the local jurisdiction because it is subdividing property or changing some lines, or for whatever purpose it falls within the jurisdiction of the local government, and so they get a bite at the apple and they approve or come back with comments for your plat. Surveyor certification 2, or little I. So this is where a plat requires local approval, but it has been approved via an approval table. Now the way this works is, it was kind of envisioned at the time that these online portals, at that time, some counties that I worked in North Metro Atlanta, would send you letters. It's just a form letter, but once you submitted your plat, the water department, the stormwater department, the engineering, the environmental health, planning department, everybody would send you letters that said, we have approved your plat, or we want to see you show the nearest fire hydrant, or we want to see this, or we want to see that, or it's just approved. So if it said this is approved, then we would say, okay, Mary Smith, Stormwater Engineering Department approved at this date, and this would be filled into a table. Rather than the actual signatures and stamps going on the drawing, the dates, the names, and the departments, those 3 items had to go on a table. We also envisioned that a lot of counties, and especially smaller counties, and we find this to be the case with counties that we work in, we can email them a plat and they will email us back an approval. It's just an email that says, yes, this plat is approved. And so we document the name, date, and person, or the name and department and the date of the approval into a table. Sometimes there's just one line on the table, sometimes there's 2 or 3. It could be as many as there are there. So, again, and also, the other little I certification 1, has this same language. I didn't go over, but that the approvals or affirmations should be confirmed with the governmental bodies before any purchaser relies on it. So it's not impossible that a surveyor would give out a signed copy of a plat with certification 1 or 2, and then a client, a realtor, an attorney, whoever, shyster or in good faith, goes and gets it scanned, or takes your PDF if you gave it to them, and gets it e-filed somehow. So if it doesn't have those certifications on it, if the clerk doesn't check those, then that plat's recorded. The surveyor, again, I was involved in the legislation. The surveyor's got some right to be concerned there, because, hey, this says that this has been approved, but it's not. So am I at fault? It's one reason this sentence is in there. Whoever's relying on these approvals needs to confirm them before they rely on them. So that kind of takes it off the surveyor. It also takes it off of the clerk of court. And again, the standard language you'll see in all 4 surveyor certificates. The undersigned land surveyor certifies that this plat complies with the minimum technical standards for property surveys in Georgia. So that is common. We move to certificate 3, or little III. This is my favorite because before the 2017 Plat Act change, some counties required planning and zoning to approve every single plat. So what happened? People didn't record their retracement surveys. They only recorded what they had to. So Cert 3 is for a retracement of an existing parcel or parcels of land and does not subdivide or create a new parcel or make any changes to any property boundaries. The recording information of the documents, maps, plats, or other instruments which created the parcel or parcels are stated hereon. Now, the the county commissioners and the city government folks were really nervous. They didn't want people to to be able to record a plat without them touching it. And part of their concern was legitimate. Part of it was a little government overreach, in my opinion. But the legitimate part is that people would go to try to pull a permit, and they would say, "Oh, but I've got a recorded plat. You got to give me a permit. I've got a recorded plat." Well, recorded plat and approved plat are 2 totally different things. So we worked with the legal counsel for the Georgia Municipal Association and came up with the language, and they said it had to be in all caps. Bold if we could make it, but you can't do that with law. It's either capitalized or regular. So this has to go on there. It says recordation of this plat does not imply approval of any local jurisdiction, availability of permits, compliance with local regulations or requirements, or suitability for any use or purpose of the land. So the clerk's office was, or the county and city governments were okay with this language, because if somebody brought them a plat recorded using certificate 3 and demanded a permit, they could point to this capital letters and say, "You should have noticed. You're on your own. We're sorry." And then they're clear. Again, the last sentence says the surveyor certifies that this plat complies with the minimum technical standards for property surveys in Georgia. Cert 4 is an odd bird. It's rare. There are at least a couple of cities and at least a couple of counties in Georgia that have no subdivision regulations and no zoning. You can do whatever you want to. They don't care. Just record the plat. There are also a few little nuances around the state. For example, one county down in southeast Georgia, when this law was passed, they had a county ordinance that says that if it was divided into 5-acre parcels or more, that they were not subject to the subdivision regulations, and the plats were fine without approval. So certificate 4, or little IV, was crafted for that situation. In other words, we were trying to make a certificate for every scenario that we could think of where a survey would possibly need to be recorded in Georgia. So this just says the property lies completely within a jurisdiction which does not review or approve plats or this type of plat. So if you're in Glenn County and it's 5-acre cutout and County Ordinance 1234 says you don't have to submit it, then this is the applicable certificate. If it's a 4-acre plat, it's not the appropriate certificate. If you're in Chattooga County, Georgia, or the city down in central Georgia that doesn't require it, and there's a couple of others that don't come to mind, then you can slap certificate 4 on it. The clerk will smile and record it, and poof, you're done. Other information, Section B of the law says the surveyor, this is important, the surveyor shall sign on a line immediately beneath the certification on the plat. So you got these certificates, 1, 2, 3, or 4, and then right below that is the line that the surveyor has to sign on. You can't, if you sign across the seal, there's nothing that says you can't, but that's kind of dumb now. But you still have to sign it on the line. So why sign it both? I do see people that do that, and it strikes me as odd. But you have to have a box with certificate 1, 2, 3, or 4, a line immediately underneath it with the surveyor's signature on top of it, and the seal has to be within or adjacent to the box, or to the certificate, which falls within a box. So you can add other certificates, other dates, signatures. If it's an ALTA survey, and you got to put the ALTA certificate on there, that's fine. You can put both. It does not negate the statutory requirement to put one of those 4 certificates on there. If it's a SBA or a HUD, they've got their own certificate, or that particular lender or underwriter has their own certificate, then that's still not an option. You still have to put the surveyor certificate in there. Moving on down, there's some other elaboration. Paragraph 4 is kind of confusing, but it falls back to where there's an ordinance or a resolution that says we don't review plats if they're 5 acres or larger, or whatever that criteria is. This section 4 is just clarifying that. Section 5, the surveyor, regarding retracement surveyors, the surveyor must state clearly the recording information that creates the plat, so that, retracement means this is the existing boundaries, we're not changing anything. One thing that used to trip people up, including myself, and some of the metro counties where the planning staff was very engaged, for lack of a better way of putting it, is if there were gores or overlaps or areas in question and they weren't the minimum size for that zoning district, they would have a spasm. 0.02 is not big enough. Please remove parcel B. Well, we really can't. It's an overlap, or it's a gore. It's got to be dealt with. Well, no, it can't be a buildable lot. That's not big enough. Well, we're not subdividing. We're not creating a lot. We're identifying what's going on so that the lawyers can fix it. Well, they never seem to understand that. Subparagraph 5, or little v here, clearly says the depiction of gores, overlaps, or other parcel delineation as may be necessary to remedy or address title issues or deficiencies shall be allowed as part of the retracement function. So you can use, that certificate 3, the retracement, even if it's got gores and overlaps and areas in question and adverse possession claim and all this stuff, you can still do it. And one of my favorites here is subparagraph 6, plats that bear certificate 3, the retracement certificate, here's highlighted, shall be entitled to recordation without further review or local approval. So when you put certificate 3 on a plat, it's okay to be recorded right then. The clerk can't really hold it up and require local review. Then we move to paragraph D. This is some municipality. It basically says when the local government has subdivision or zoning regulations, they have to be complied with. E says a surveyor who fraudulently makes any certification. So if you know it's not been approved and you certify it anyway and you record it, you're guilty of a misdemeanor. Now this is important because the clerks got tired of some surveyors issuing certificates and getting things recorded back years ago before the 2017 law. I don't know if it still goes on or not, but they specifically said in the halls of the Capitol, we don't want to have to fool with trying to file a board complaint or trying to get a property owner to sue a surveyor. It's never going to happen. We want to be able to walk across the hall to the district attorney's office and have charges raised and filed against the surveyor if they keep doing this, if they fraudulently make any certification. So you're not in getting sued or dealing with the board, you're dealing with the long arm of the law and the criminal justice system at that point, even though it's white collar in nature. F and G just talk about the clerk of the GSCCCA's authorities. And little I just says that if a survey was prepared before May 8th, 2017, which is the effective date of the law, then they may be recorded. Don't have to be recorded. The clerk still has discretion to look at it and say, I don't think so. But this paragraph or subparagraph specifically gives the clerk of court legal authority to record older plats. Why is that important? Say that there's a surveyor that issued a perfectly good plat in 2016 or 1996 for that matter, and now he's passed away or he's retired and moved out of state. You can't reach him. But you've got a perfectly good survey with his signature, met all the requirements of the day that it was issued. Well, what do you do if it doesn't have a 3-inch square box because that wasn't in existence in 2016 or in 2015 or 1996? Well, the clerk has the discretion to allow you to record them anyway. That's what little I means. Now we move over to board rules. Rule 180-7-.07 is the chapter of the state board rules on maps and plats. So the very first introductory paragraph here will sound familiar if you were paying attention 30 minutes ago. All maps, plats, and similar documents which depict and describe real property boundaries. Remember that, which depict and describe real property boundaries shall comply with all requirements of Code Section 15667 and conform to the following standards and specifications. There is a provision here that, if you think about it, a topo where you're showing boundary lines by another surveyor, or maybe you're showing boundary lines based on a preliminary, you didn't fully research it, you're just doing a topo. They didn't want a boundary survey, or it's a preliminary plat. If it's a preliminary plat or a concept plan or a grading plan that's being submitted and it's got bearings and distances on the property lines, you don't want to have to put the equipment used, all the adjoiners info, the 3-inch square box. That's not the applicable place. So this rule, this paragraph right here clarifies that the source of the boundary information shall be shown and bear a note to the effect that the surveyor certification, which would not be one of those 4, it's just the fact that it's sealed and signed, that's the certification that this rule is speaking to, extends only to the topographic and or geospatial aspects shown hereon, and that a topographic survey does not constitute a boundary survey, and that this is not to be recorded or used to convey title or interest in the property. So if somebody records it or tries to get it recorded or uses it in a deed or something later on, after you have done your job as a surveyor and put these qualifying languages on there, then it's on them. And they should, we can't fix stupid people still record or try to record preliminary plats and sketch plans and sell lots off of it. So, paragraph A goes on, that they must be clearly legible, they must have sufficient line and character heights and weights that they're legible when copied and scanned at 300 dpi, dots per inch. Paragraph B, they shall require the following information. So here we go back through much of the same thing. The entity who authorized the survey, or the name of the client, etc., the county, landlocked district, GMD, reserve, etc., the dates of the field work. This is not in the state law, but the date, the date of the survey is in the state law, but in the board rule, the date of the field work, the plat preparation, and all subsequent revisions, including a brief explanation of each revision, which is synonymous with the law. 4, square box, 3 inches by 3 inches. So it's in both places. It's in the board rules and it's in the Plat Act. So if it depicts and describes real property boundaries and it has a surveyor seal and signature, it's got to have a 3-inch square box, as well as the scale, as well as the surveyor's firm information, including the certificate of authorization number, or that language that it's a surveyor who's either not required to be licensed because he's a pre-78 elected county surveyor, or because he's working, him or her is working in their own specific individual capacity. Number 7, we got to include the applicable surveyor certification, and the original maps or plats shall be retained by the land surveyor or firm in hard copy or electronic file, blah, 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 for a period of 6 years from the most recent date on the map or plat. Why is that important? Georgia has the statute of repose of 6 years. Some people mistakenly but commonly call it the statute of limitations. But the surveyor's liability window starts from, as the statute clearly states, the date on the plat, not the date of discovery. That's the qualifying difference between a statute of limitations and a statute of repose. So basically, this 6-year data retention requirement means that for as long as the surveyor is on the hook for that survey, 6 years, they have to have all the data and be able to back it up. So this is in there for one reason, to know that it's not indefinite, that you don't have to keep it forever, but it's there so that you always have to keep it. And an interesting story on why I made sure this got put in the rules several years ago was we had a very bad actor who had obviously merely copied the subdivision plat, did a terrible job, except he perfectly copied the bearings and distances off of the subdivision plat. Had the house in the wrong place, a whole bunch of other problems. And so we subpoenaed his field notes, which would show that he had done little or no field work and that it wasn't compliant with the measurements rules. And his attorney simply said, my client burns his field notes after every survey is issued. He has none. And you have no records retention requirement in Georgia. So now we do. So as long as the surveyor is on the hook for a survey, that surveyor or their firm has to maintain all the data that goes into preparing the plat. Paragraph C, the size, be of a size that is commonly available. What does that really mean? 17 by 22, 18 by 24, 24 by 36. You're not going to get all this on a letter size plat and it be legible. Sorry, it's just not going to happen. But here's the thing. If you just let your software say 1 inch equals 86 feet, or 1 inch equals 150 feet, that sounds good. That's a good fit. 1 inch equals 100 is too big. 1 inch equals 200 is too small for this size paper, so we'll just make it 150. No. The rule says to a scale in feet commonly found on an engineer's scale, or to a scale in chains commonly found on a forester's scale, because still some surveyors that do huge timber tracts in South Georgia, they don't do 1 inch equals 500 feet, or 1 inch equals 600 feet. They'll say 1 inch equals 10 chains or whatever, and it makes sense for them for that application. So it can't be 1 inch equals 75 or something weird. If it's not on the common, readily available 3-sided engineer's scale, or the 2-sided pocket scale, then it's not an acceptable scale. Why do these things matter? It might not ever come up. It might make for a better plat to do 1 inch equals 75 feet. But the clerk's authority, the realtors, a lot of the attorneys want it plotted so it can be plotted to scale and be scaled. This actually has more legal basis than might meet the eye or than you might think of, because scaling dimensions and scaling features to property lines and things has some root in the court system, in precedent cases, to where scaling these things has been brought up before. So basically, and I have had to do it on the stand, where a plat was put in front of me and a scale was handed to me and said, according to the scale, how far from the property line is the closest corner of the house on this survey, Mr. Chastain? So that's a function of law that doesn't care about CAD programs and pixels. It's something that you've got to be able to take one of these and, while on the witness stand, go through. Sorry. So use an available scale. Don't make up a weird scale. More content, indeed, a point of reference. We could talk an entire session basically about a point of reference. This is required. Point of reference shall be an established, monumented position which can be identified or relocated from maps, plats, or other documents on public record, including state plane coordinates when applicable. Now, bearings and distances shown on the survey shall be based. Actually, let's come back to that. The point of reference. Okay. The board rules are just saying that we have to tie our boundary to a point of reference that meets these criteria. If it is a right-of-way intersection monumented by a concrete monument in Bryan County, that's adequate. That meets all these requirements. You can go to DOT plans and old surveys and know where that concrete right-of-way monument is. That's wonderful. It can also be as simple as a corner of a platted lot. Even a four-sided lot arguably has 4 points of reference on them because they're established monumented positions which can be relocated from maps or plats. It can't just be something that's just stuck out in the ground to begin with. If you're doing a division survey, you still have to tie it to something that serves as a point of reference. Now, there's a little bit of elaboration that's required here. State plane coordinates on an IPS are not sufficient. State plane coordinates don't show up on any map, plat, or other document on public record. They're not in the chain of title. The title examiner at the courthouse cannot correlate state plane coordinates with a piece of property on the ground or on a chain of title that goes back to the royal government of England. State plane coordinates don't tie in there. The reason the mere mention of state plane coordinates is in there, and notice it says when applicable. The very scenario is if you have large timber tracts, 1,000 acres apiece, and they all join in the woods at an iron pipe. And all the deeds just say north 82 chains to an iron pipe, or fence to the northeast corner of Jones being an iron pipe, or whatever. You find the iron pipe, there's painted lines, there's fences, there's timber breaks. Property owners going, yes, that's our corner, whatever. Well, is that a position that can be, I mean, it's established, it's monumented. Can you relocate it from maps and plats on public record? Yeah, that'd be kind of tough. You'd have to duplicate the exercise to get all those property owners back out there. What if they all die over the next 50 years and it's 50 years before anybody tries to retrace your survey? That's when including state plane coordinates when applicable is applicable. So some surveyors think they can just go pop a pin in the ground, dial in on the network, or get an Opus solution and say, that's my point of reference. No, it still has to meet everything else. You can throw state plane coordinates in for additional flavor if you'd like. They are not on their own a sufficient point of reference. Do not confuse a point of reference with a point of commencement or a point of beginning, which are legal terms, which are discussed separately. Paragraph 2, all of these bearings and distances, here's the emphasized part, highlighted, shall be based upon the measurements of the surveyor. The one exception is, for example, in an ALTA survey where we're supposed to, although it's usually waived in Georgia, supposed to state both the measured and the record dimensions. We can show both as long as we make a clear distinction as to which is which. We're not being paid to plagiarize a survey that somebody else did. We're being paid to survey boundaries and measure those boundaries and evaluate those lines and evaluate the monuments and evaluate the adjacent descriptions for gores and overlaps or hopefully nice tight conformity. They're to be based on our measurements. A lot of maybe the national firms or surveyors from other states where they just hate to change anything have a hard time with this. That's unfortunate, but not an excuse. If the record plat says 500 feet, you go measure it and it's 499.96. Hip hip hooray, we're well within all of our tolerances. That's great. You better put 499.96 on your plat. Do not put 500.00 on the plat because that was the last surveyor's measurement. You've just violated state board rules. And here's proof of it. I'm not making it up. You can read it for yourself. Shall be based upon the measurements of the surveyor. So no copycat plagiarizing allowed. Number 3, we're required to provide a closure or precision statement for our field work. And it shall not be a generalization. So 1 in 10,000 plus, 1 in 50,000 plus does not cut it. That's a generalization. It has to be calculated from the surveyor's actual field measurements. If the surveyor determines that a closure precision is not appropriate because a substantial portion of the field measurements were obtained using GPS, then a note of precision or positional accuracy may be placed in compliance with the GPS rule. If the surveyor didn't use GPS but made redundant measurements, for example, a 2-point traverse is not really a traverse. A 2-point survey where you occupy 2 points but you locate other points redundantly from each position. That's like a 3-point traverse without a closing angle, but that's called a coordinate check. That's a redundant measurement that can use to verify the accuracy of the survey. Then there is a note that the surveyor can state that. So if I do a 2-point survey and I locate 1 point from both points, both instrument or occupation points, the inversed or computed distance between those 2 points is the positional accuracy that I put on my plat. You can word it almost however you want to, as long as it's clear. Might say, with to within 7/100ths of a foot, 1/10 of a foot, whatever it was. Map closure. We have to run an independent map closure of the bearings and distances on our plat. This is not an option. If your software kicks out a closure number, that's great. If everybody's doing their job, you'll come up with the same number when you independently run the map check off of your plat. Why is this important? Calls get deleted. They get stuck on frozen layers. Call tables get moved outside the borders. There are plats that get recorded without this stuff on it. Whereas if the surveyor had merely followed this rule, which has been here for at least 40 years that I know of, and run up a map closure, they would have figured out, oh, I left that off, or I must have that on a frozen layer. Sometimes the call is to a point next to the corner made in haste or made by mistake that's only found when you figure out, wait a minute, I shouldn't have 2 feet of closure error in my boundary. So we have to state the closure precision, then it shall be based on an actual map closure that has been independently calculated by the surveyor using the bearings and distances from the face of the plat, and shall not be a generalization. Again, 1 in 100,000 plus, not going to comply. You run it up and it's 1 in 113,419, that is the number that gets placed on the plat. Very clear rule. Moving on, widths and former widths of pertinent of easements or right-of-ways, encroachments, observed evidence of human burials or cemeteries. In the case of a curved line, you got to put 4 components on there: the radius and the arc length, the chord bearing, and the chord distance of regular curves. Chord distances and directions can be given for irregular curves, such as a stream maybe, or an old road bed, or an irregular road for that matter. It's called chording it off. You don't have to fit curves to every road out there. Land lot lines, district lines, section lines, all these things need to be on there. If you're nervous about maybe this is not it, maybe this is it, I don't know exactly where it is, it clearly says that we can use such labels as apparent, or accepted, or approximate, or other such qualifying language as the surveyor may deem necessary or appropriate. Number 9, corner markers and markers of pertinent reference points shall be fully described and indicated as to the material or type, size, or dimension, and whether found, set, or replaced. Now, I'm going to talk about replaced for just a minute. In the case of badly disturbed or deteriorated monuments that are replaced for the purpose of position preservation, the survey shall indicate the size, type, and material of both the found and the replaced monuments. So I've done this. You dig up, I dug up an iron pipe that I presume was set around 1910 in the city of Atlanta on Piedmont Avenue. It was about 3 feet deep in the ground. It had a good magnetic reading, but when I got down to it, it crumbled. And then I could see part down below that was still a pipe. Still, I stuck my finger down in it, and I could tell that it was iron pipe, but it crumbled. It had been there for 100 years or more, and it was, well, at that time, not quite 100 years. I've also found crimp top pipes that have got water in them and they're deteriorating and falling apart. got to be able to do something with those. So instead of just saying 3 feet down, there's a 1-inch iron pipe, badly crumbling. No, what we did was we precisely located the position of that pipe, filled in the hole, packed it in good, went and got a rebar and cap, set a good monument on the surface, noted on the plat, 5/8 rebar set at remnants of 1-inch open pipe, badly deteriorated or badly rusted. So those are instances when you might want to do that. I've saw where last surveyor said a 8 by 12 inch planted stone was the corner. Well, when you get there, you just got a crushed up rock pile. Maybe it was in a fire break and a bulldozer ran over it. Well, you determine as best you can where that is. You just got a bunch of small rocks scattered around. Set a pin, so that there is a good permanent position. That's called replacing a monument. Now, getting back to the point I wanted to make, IPF or RB, not adequate. You don't have to spell out a paragraph and say 1/2 inch capped rebar found, but if that's what you found and that's what it was, then you need to relay that. You can do that through various symbols and a legend. For example, some of my plats, I just say IPS, but it's a solid circle. If you look over at my legend, a solid circle is an IPS 5/8 inch capped rebar. So I'm providing the type, size, and material, and that it was set. I've saw surveyors show an open circle or a filled circle for that matter that says, this equals 1/2 inch rebar found, which if every pin on the job is a 1/2 inch rebar, it maybe seems a little lazy to just cop it out on a symbol, but it also seems a little redundant and laborious to stick 6 IPF 1/2 inch rebars all over a plat. So anyway, regardless, the person who comes behind you needs to be able to look at your plat and know if you found it or set it, how big it is, and what it was. So if it's a 1-inch by 1.5 inch oval rod, that's what you put on the plat. Don't just say IPF. Don't just say rod. It needs to say the material or type, the size, and whether if you found it or set it. Sorry, period. You got to have a north arrow. Reference it to grid, magnetic, or what you referenced it to if it's a record bearing. Distances have to be ground distances, not slope distances, but on the topographic plane where the survey is being conducted, because that is where the title is vested. It's not vested down on the grid or down on the ellipsoid or up on the grid or up on the ellipsoid. You can see some good distortion on say a 40-acre tract. You can make 1/10 or 1/4 of an acre's difference in the computed area in some parts of the state based on where you are elevation wise and in relation to the principal meridians of the grid zone. But don't use grid distances. That is not, should it be necessary? Should somebody be requiring you to state grid distances? You need to show both grid and ground. So if you're showing grid, you need to provide the elevation factor and the grid factor or the combined factor. It says and the combined factor, but basically we show either the first two or the last one. Bearings and distances shall be in degrees, minutes, and seconds, which should go around the property in a clockwise direction. We can show azimuths or interior angles, but not in lieu of bearings and distances. We do see old plats that just show interior angles or azimuths. No, you got to have bearings and distances. Why? Because that's how real estate attorneys describe property and understand what they're looking at, as well as the public, as well as GIS departments and mapping departments. Number 13, we have to include the type of equipment used. Number 14 is very important. Remember the research rule, the very first rule, 180-7-.01. Something else that has to go on the plat, the names of adjacent property owners on all lines. That includes railroads and highways, county roads, city streets. along with a notation as to what documents were reviewed for each adjacent property as required by Rule 180-7-.02. I said 0.01, must be 0.02. So, such notation may be the deed book and page of the recorded title description, might be recorded plats, might be other documents or surveys that were obtained through the course of the survey. Maybe they were unrecorded and the neighbor gave you one. Maybe you found one in the crusty old files of the tax assessor's office. In the case where the adjacent property is a recorded subdivision, it is sufficient to state the name, the phase, the recording information along with the lot lines and the lot numbers. You do not have to put every individual owner. If you back up to a subdivision, you got 20 lots that you abut it, you don't have to list all the lots, but you do have to review all of their deed references. You need to make sure that they call for that plat and that lot on that plat. What if it says lot 16 and a 10-foot strip to the west of it? That might be 10 feet out of your property. That's something that has to be evaluated and reviewed. Or maybe it's, not uncommon to say lot 16 and the northern 10 feet of lot 17. In other words, went from 100 foot wide to 110 foot wide because they wanted to build a swimming pool or they had built a garage over the line. These are the things that lawsuits are made of, is when that sort of stuff gets overlooked. So even though you don't have to put now formerly Mary Smith, deed book 1, 2, 3, 4, page 5, 6, 7, you still got to look at them. You still have to evaluate it. So this rule means we've got to put whatever information we reviewed to comply with 180-7-.02. That's what we put on our plat. That needs to go on there. I see situations where people merely regurgitate the book and page from the tax assessor's website and stick it on the plat. That don't do it. You have to review it, analyze it for conformity with gores and overlaps. It's not an option. Water boundaries must be shown in sufficient detail to clearly identify the surveyed tract and the adjoining tract. That kind of goes without saying, but that's also basically saying that you can use a meander line. Along each line, paragraph 16, evidence of possession or along or related to the boundary lines. If there's fences, if there's a big mow line, if there's a rock wall along a property line, you need to show it. Clearly depicted and stated, and any gores or overlaps in compliance with 180-7-.02. So you can't just say, yeah, there's a problem with that line and just gloss it over and act like it never happened. It has to be depicted. Any of the features that the client requests. 18, the type of survey. Here's something else. We have to list the source of the title description of the property being surveyed. So you can't just say this is tax parcel 155. You're retracing the property described in deed book 1, 2, 3, 4, page 5, 6, 7, along with the current owner. If you remember back, that's a requirement of the Plat Act, so that's a requirement to be shown as well. GPS rule, if you're using GPS or GNSS to do surveys, you have to add a note stating which portion or all the survey was used. Use GPS equipment, the type of the equipment, the manufacturer, the model number, whether if it's single or dual frequency. This rule is a little outdated. Most of us now use multi-frequency, which carry L5 or 3 total frequencies. So I use the word multi-frequency on my plats. The type and disclose the precision of the GPS work done. Typically I do that by a redundant measurement. I don't think it's totally kosher to say this is the statistical analysis of our data. I think you got to have something, but it does give a lot of latitude right there. And it says relative positional accuracy or other mathematical expressions. So, you got a pretty good latitude there. It was recently adopted in 2025 by the Georgia Professional Engineers and Land Surveyors Board. There's a land survey plat conformance checklist. Notes or other requirements not covered by the checklist. Checklist is not intended to be all-inclusive for all surveys or plats. It is the responsibility of the land surveyor to know and apply all rules and board rules that may apply to their specific drawings. So, this is not a cure-all, do-all, but everything that we've been talking about, is backs up these things. So there's two parts. There's border elements and drawing elements. The border elements list the things that you've got to put on the border. Don't necessarily have to be in the border, but these are the things that has to be on every plat, period. the north arrow, the 3x3 box, who it was prepared for, the calculated field precision, etc., etc. Drawing elements, these are the things that have to be in the guts of the plat, the adjacent owners, the deed reference for the subject plats, property corners, description and type, a point of reference, any easements, boundary line evidence, etc. So that's what breaks this up. And finally, one of my favorite slides, when people would tell me when I was on the board, well, this don't apply, this is just a loan survey, or this was not intended to be recorded, so it doesn't have to meet all these rules. No, this goes back to 1989, almost 2.5 years into my career as a surveyor. Of course, I was a junior in college, I guess, at this time, but the board issued this letter regarding loan surveys. So this position predates even my licensure, much less my term on the state board. This has been the legal position of the State Board of Registration since at least 1989 and probably further back than that. The board has received many official and unofficial complaints regarding loan surveys, loan plats, mortgage inspection reports, etc. And I underlined this myself. The board makes no distinction between loan surveys and any other surveys. So if the client says, you don't have to go around all my property, the bank just wants to see where the house is, I'm sorry. You got to survey the whole boundary. You can't just fake it in. You can't just do what the client wants. Kind of like, you don't go to the doctor and say, I don't want to run a physical. I don't want you to draw blood or x-ray me. I just want you to take out my appendix, okay? The doctor ain't going to do that. Sorry, you can't just do part of your job. You got to do all of it. The board realizes that many times the lending institution or the person who requires the survey does not want to pay for an actual survey. Listen closely. This does not relieve the registered land surveyor of his responsibility in making a survey in compliance with the Official Code of Georgia 15667, which is the Plat Act, now the Plat and Condominium Act, which in more than one place ties it right back into the board rules. Any surveyor doing loan surveys or any other survey in violation of this aforementioned code is in jeopardy of being disciplined by the board. So don't think this is anything new. If you have learned something different or heard something different somewhere else, I'm sorry, you heard wrong. This is the authoritative position of the board since 1989. Hope you've enjoyed part 2. Stay tuned for part 3. Thank you very much.